Hi, I'm Faisal Bhabha. I teach at Osgoode Hall Law School. The Ontario Human Rights Code turns 50 in 2012, and opinions are polarized as to whether it's still necessary. On the one hand is the view that litigating human rights has not only failed to eradicate social inequality, but that legal action may actually contribute to further inequality by pushing people's attitudes to extremes and generating backlash. The truth about rights litigation is that it often disappoints even when successful. In the US, issues such as abortion, affirmative action, and gay rights are still unsettled despite years of litigation and millions in legal fees. In Canada, restrictions on hate speech and questions about religious accommodation remain politically provocative. Yesterday's rights victories may still be tomorrow's battles. At the same time, there's no doubt that human rights law has at times protected vulnerable people's interests. Moreover, it has altered how people see themselves in relation to others, how they talk about the conditions of their lives, and how they challenge authority. Human rights have changed norms and practices. We no longer accept that women can be fired for being pregnant. We don't accept children with disabilities being excluded from public school education. We don't accept racial or sexual harassment in the workplace. It doesn't mean these things don't happen, but we mostly agree that these things shouldn't happen. Yet, there remain realities that make it hard not to be skeptical about using a rights paradigm for solving deep social problems. Staggering disparities in wealth, glass ceilings for women and minorities, a largely inaccessible built environment, disproportionate criminalization of members of vulnerable communities, and the continued lack of affordable housing and income support for poor people. We have a process to fight discrimination on a case-by-case basis. But while individual cases might solve individual problems, it's not clear that they lead to direct change in systems that are the root causes of inequality. Rights litigation doesn't necessarily change attitudes or behaviors for the better. To achieve these goals, we should think about justice beyond rights. This kind of justice might adopt a regulatory framework. It might include monitoring and teaching rather than litigating. It might involve collaboration and negotiation rather than adversarial positioning. And it might mean moving away from a purely grievance or complaints-based system towards one that involves standard setting, training, oversight, and other comprehensive strategies. At 50 years, the Human Rights Code may have served much of its original purpose, but as people increasingly think of their interests in terms of rights, the demands on the human rights system will continue to grow. Formulating new approaches to how rights can serve the cause of justice will be essential and will likely be the standard by which today's human rights legislation will be evaluated 50 years from now.